Such a pleasure to have you all here. My name is Giovanna Fessenden Fairbank. We have a phenomenal panel of Gen AI legal experts. And as a roadmap for our discussion today, we're just going to go through some brief introductions to each of our panelists. We're going to do a quick overview of Gen AI and how models are generated. And then we'll do a deeper dive into the legal risks, compliance recommendations, governance, best practices, scalability, open and closed models. So it's going to be a very fruitful discussion. We will follow up with a question and answer session around 1 p.m. So please share any questions for our panel in the Q&A box on the Zoom interface. If we have a chance, we'll take those questions during our discussion. Otherwise, we'll get to them. We'll try to get through all of them, as many as we can, at 1 p.m. Today's event is sponsored by Hamilton Brooks Smith & Reynolds, and Hamilton Brooks Smith & Reynolds, HBSR, is an intellectual property law firm with offices in Boston, Seaport, and Lincoln. HBSR has been advising clients all over the world for over 40 years, providing top-notch legal counsel on patents, copyrights, trademarks, IP litigation, licensing. We have a team of technology experts with backgrounds in every area from clean energy, AI, biotech, every technical dimension. And I have the distinguished honor of being of counsel at Hamilton Brooks Smith Reynolds, and I'm also on the executive board at the Berkshire Innovation Center. My background is in computer science, and I've been practicing intellectual property law and managing my clients' global IP portfolios for over 20 years, specializing in software innovations, blockchain, AI, providing litigation, trademark branding, and counseling and licensing. So now I'm going to have my fellow panelists introduce themselves. Steve is delayed, so he should be popping on soon. Leslie,
yeah.
I'll hand it to you.
All right, thank you. Thank you, Giovanna. My name is Leslie Long. I'm intellectual property counsel with Dassault Systems, French company, if you couldn't tell by the name, but our U.S. headquarters is based in Waltham. So live from there right now. So my background is also in computer science. Prior to working at Dassault Systems, I was in intellectual property licensing in a university setting. Title is intellectual property counsel, but have sort of become a jack of all trades. So work with IP, work with privacy. For people who work in-house, you sort of get to be a generalist whether you want to or not. But AI has brought up a lot of fun questions in all of those spaces. So.
Great. Mary Lou?
Hi. Thank you, Giovanna. My name is Mary Lou Wakimura. I'm a principal at Hamilton Brooks Smith Reynolds. I've been practicing with the firm as a patent prosecutor for over 35 years. Large section of the technology area that I deal with is computer-related and software innovations, and mostly representing those stakeholders at the U.S. Patent Office and abroad on such technical innovations. And more recent years, that has overlapped into open source software, other copyright type of issues dealing with the whole IP umbrella of how to best protect and monetize our assets for clients as far as these technology areas in software.
Fantastic. Well, let's dive in and start getting
Giovanna.
into. Oh,
And Steve is here.
Steve has popped in. Wonderful.
They admitted me to the meeting. Apologize for the delays. Steve Kurlowitz, I'm Chief IP Counsel for Kyndryl. Kyndryl is a spin-off of IBM about 2.5 years ago that works in the managed infrastructure services space. Background in computer science, IP law, with Hamilton Brook for 4 years, as well as in-house with IBM for about 20 and Kyndryl for about 2.5 now, and currently working with AI, generative AI, and the overlap with IP.
Fantastic. Great. So now what is Gen AI, right? So AI has been around for well over a half a century, and Mary Lou, Steve, Leslie, and we've all been practicing protecting AI-related inventions for decades. But more recently, AI models became generative. And historically, AI models were trained on much smaller data sets specific to a particular domain, like faces to enable facial recognition, for example. But now LLMs, large language models, are trained on vast amounts of data, and they can achieve impressive capabilities. They use deep learning and transformer models to understand and generate new content. And that's why it's called generative AI. It's generating new content. So let's dive in on how Gen AI models are created. Mary Lou, would you like
Sure.
to touch base? Yeah.
Sure. So this current chapter or variety of AI, the Gen AI, uses large language models. Those are the models that not only learn keywords or key phrases and tries to pinpoint a pattern. That's the older generations of AI. The large language models learn context as well as the individual words. So that context involves sentence structure, paragraph structure, and understanding that infrastructure, the large language models are able to then generate new content, having that structure in place. In addition, the open source community has been active in the Gen AI space. And so there are open AI models being shared, and those are also based on the large language model approach, so that new content can be generated from these machines.
Great. So there are, open models and we have closed models, and there's a lot of advantages and disadvantages to using each type of model. Maybe Steve, Leslie, you want to opine about sort of the distinctions between open and closed models? And
Sure. So for, open models, typically the weighting, so, basically how the model itself is generated is able to be edited. Fine tuning is the term usually used. And you can download and run the model yourself on your own local hardware. Assuming you have the hardware capable of doing it, that's often the practical limitation. Closed models tend to not be available directly, but available as a service. So it's a web service. You have an API that you can call and you get an answer back, rather than being able to run it yourself locally. And there's different variations of that. Sometimes there are models that are distributed, but the weighting is not able to be edited. So that's more like a closed model. The closed models tend to have much higher hardware requirements. Training takes, sometimes millions of dollars of compute time to effectively do and even running it requires, hundreds, if not hundreds of gigabytes, if not terabytes of video RAM. Open models tend to be smaller. Some can even run in, local desktop hardware if you have a high-end GPU. Some are designed specifically to run on basically a certain level of hardware. I mean, I've seen some that are designed to run on Raspberry Pis, which is commodity $50 hardware. So it's, you really have to look at a couple of different levels of compatibility of not only cost, but also, what access to compute do you have, and capability of the models. I think the closed models tend to, in general, be a little bit more capable, but that's because there's large amounts of money being thrown into them.
right. And so with the open models, you have an opportunity to tune it, but there's also a little more risk. Like with a closed model, it can be more customized and tuned to make sure that it doesn't that the prompts cannot be poisoned per se to prevent the model from generating content that may be nefarious or discriminatory or unethical or along those lines. But with an open model, you're going to have, that's sort of up to the end user to try to figure out how to tune the model, how to tune the weights to make sure that it's going to not generate content that could be problematic. What are Steve? What are your thoughts on some of the distinctions? Yeah,
another distinction I think between the two you have to look at, as Leslie said, the closed models are usually offered as a service. These are not distributed software, enormous compute needs, enormous storage needs. Never mind to train them and build them, but to operate them and deploy them. One of the differences with the open source models, you're deploying it yourself, on your servers, or very likely, some instance of a generic virtual machine on an AWS or Azure or Google Cloud platform. But it's your deployment of them after you've, tweaked the weights and other things you've done, as Leslie was talking about. You now deploy it. And, as with open source software, no warranties, no indemnities. So you are on the hook for that, and including potentially, depending on how you host it and what your contract says, for indemnifying for the outputs of your model. With the with the services for commercial models like Microsoft Azure, OpenAI services, your outputs are indemnified. You get an indemnification should they be presenting a copyright infringement risk to you. You must do often some technical mitigations in how you form your prompts and how you use the model to stay within the swim lane of the protection of the indemnification. But for those deploying them, that is another major factor on top of the resource requirements to run them, to make them operational.
right. And so that indemnification is obviously, it's huge. It's huge because it mitigates legal risk, and certainly would help protect the company. But the trade-off is there are a lot more resource intensive financially and, in terms of your resources, your computing resources. So that's comes with the package. So in terms of open source, the open source initiative came out in April with a definition for open AI, for open source artificial intelligence models. So OSAID, and it's a definition that they proposed that basically, they're trying to create like an open source requirements to have freedom of use and study, to share the system for any purpose. But a lot of the open source models that are out there now do not, they don't seem to comply with that. They're not adopting the open source initiative's proposed definition or licensing. And, one of the issues I believe that we've talked about amongst each other is that there are certain requirements of what your first open source models, which are allowed to limitations on the scope of what you can do with the model. You can't use it, for example, you have to make sure that you're not going to be generating discriminatory content, for example. Are there other restrictions you guys are aware of that for some of the open source models available that restrict your use?
I've I've seen some that try to limit specific uses, even if they aren't, outright discriminatory or for, misinformation. Some that try to limit specific fields, like, you can't use it for defense purposes. Uh, not in an AI context, but just in a normal software context. I've seen some people take open source licenses and try to restrict specific users. Um, yeah, in the case I'm thinking come to mind, they wanted to prevent the U.S. Department of Homeland Security from using its software. Everyone else could use it, but not DHS. Yeah, it doesn't meet the open source definition at that point, but you're starting to see more, I don't want to say value judgments, but substantive restrictions based on who the user is or who the use case is. The traditional 10 points of open source that the Open Source Initiative, I think that was probably put out in the early 2000s, if I remember right. That is the de facto definition of open source, but there's always been a lot of miscommunication on what is open source versus free software versus source available. And unfortunately, those get used largely interchangeably. I'll admit I've done it myself from time to time. But there seems to be a much larger shift for generative AI models for things to be called open source when they do have these substantive restrictions, where it was pretty uncommon with most open source software projects.
Yeah, I would definitely agree. And the devil's in the details, as you say. Well, if you had an open source license that was OSI license definition compliant, you could pretty much assume it was use restriction free. There are many organizations, I think, trying to define what is AI. What is an AI system? What is an AI model? The EU AI Act provides a definition different than some others that you just mentioned, Giovanna, on that. I think the lesson here is you have to look into the details of what rights you're being given on them. You can't make that broad assumption that if someone's labeled it sort of an open model, that you have some of the implicit understanding of the constraints or the freedoms that you had with open source.
And
Right.
I think it's also sort of a double-edged sword, as not only do you have to worry about it as a user, but if you're a service provider, what active steps do you have to take if you're offering it as a service to others? You might be fine with it in your context, but particularly if you have an openly available system, and an account that anyone with an email address can sign up for, it's going to get abused. People are going to try and come up with creative prompts to break it. What steps do you need to take to try and mitigate that? I think is the $64,000 question a lot of times.
Right. Well, Steve, you brought up the EU AI Act. Leslie, I know you have wrestled through it quite a bit, and I appreciate that it's not yet completely enforced. It's hard to sort of explain why it needs to be ratified in all the member states, I guess, or there's lots of processes that need to take place before it's completely in effect. But what are some of the requirements that legal compliance that that enterprises are going to need to adhere to in order to comply with this the EU AI Act?
So the way the EU AI Act frames different levels of risk. There's a few things that are just outright permitted, things for discriminatory reasons. I think price discrimination in housing, and a few things that are, I think, actively being done in the U.S. Currently, and tiered risk from high, medium, and low from there. So I think if and it's also global in scope, much in the way that GDPR is, and that it doesn't matter if you're operating in the EU, if you're offering the service or using the data of EU citizens, it's something you have to be concerned about. So, yeah, as you said, it's a little bit fuzzy on it is in effect, but it's not in force, and that's subtle distinction that I don't think we need to get too much detail into, but it really is on the individual member states to implement through their own legislation. So we have the EU law in effect, and that can provide a sort of high level guideline, but it doesn't quite have the same process that lawyers in the U.S. are probably more aware of, where you have a statutory law passed and then you have implementing regulations by whatever regulatory body is subject to those. It's will work a little bit differently, and it will probably practically end up like GDPR in that there will be a little bit of a touch and go phase of people trying to figure out what exactly the limitations are and the metes and bounds of individual parts. But and I guess the one other main requirement that I haven't seen talked about too much is that you have to maintain basically visibility of your data set. So if you're offering it as a service, you have to be able to tell your users what data is actually trained on. And what level of specificity you have to go into is not quite clear, but do you have to say data set version 1.A of this third-party provider? And what do you have to do if it's a data set of your own data or your own customers' data? That's not quite clear, but that's something that we've been looking into pretty extensively.
Yeah, likewise, with my company. Well, as Leslie and Giovanna mentioned, while not completely in force, although passed, it already is having a halo effect on those who are looking to provide some form of responsible AI governance. And a lot of people are looking to the risk framework that the EU AI Act lays out as they potentially look at their own regulations, or certainly internally, as your companies or your law firm develops standard or template governance policies, an AI policy for a company. What they're often following is that risk framework from the EU, much in the same way that GDPR influenced a lot of other data privacy regulation around the world. I think a lot of people are looking right now because it's the most advanced, mature AI regulatory body at this point of law that we have. And the other thing to keep in mind, this is something we're starting to drill down. We have a 1-year period of implementation, as I understand it, from the August in force date. You must have a copyright policy in place that comports with the EU AI Act if you are to do business using AI in the EU. And Leslie touched on this with the point about some transparency about data being used to train. And I think what they call a code of practice that you are undertaking when you're developing these AI models. I think there will be some further guidance on this from sub-agencies or other entities of the EU structure, but we're starting to look into what does that mean for the services we use. We're often using third-party services, but as was touched on earlier in the discussion, there is a trend towards smaller models, more specifically trained models that more likely will be developed by companies. These are not the Chat GPT, Gemini, Claude, LLMs that can, answer your mathematics homework, write a poem, and produce an image. These are very specific models, curated data training for a specific activity that are being done. And I think the copyright requirements of the EU, copyright policy requirements of the EU AI Act will come to bear more for companies that are building those models than for those using a commercial large language model as part of their deployment of a service or a product.
Right. So that may be one of the, a better avenue or opportunity that will be a little more strategic and valuable to companies to have a more domain-specific model that's curated specifically to a particular sector or type of data, as opposed to with the large language models, which is just almost everything under the sun. It gets processed. So that may be sort of the crown jewels for companies in the future. If they're trying to create a market for themselves, to create a product, it might be better to have one that is specific to a domain, and it's a bit easier to implement and deploy than an LLM. But when talking about, you mentioned we've talked a little bit about the privacy concerns and the copyright risks. But with the EU AI Act, requiring compliance in these spaces and transparency, it is going to be certainly challenging for operators and companies that are making products in this space to comply. And when it comes to privacy, there is this trend about trying to anonymize or depersonalize any user data or personal data before it's used in the model, which is obviously very technically challenging. But there's certainly the trend, and whether or not that will be enough to comply with the EU AI Act, it may not be enough. But these data sets that are being used to create these Gen AI models, I mean, they contain personal user data that's been scraped from the internet, typically. And so that poses a lot of legal risk for using these models out there, and which makes it more advantageous, I suppose, to use these more expensive closed models, because you get that indemnification. Do you know, does the indemnification include protection against like compliance with the EU AI Act, or is it just for copyright?
The only ones, the ones I've focused on have been for copyright infringement. But another risk mitigation other than indemnification that we're seeing is filters on the input side to make sure you're not leaking private information into a prompt, and then filters on the output side to try to detect similar things. They're not perfect. You often hear DLP or data loss prevention in this area. But I think what you'll see, both for privacy, abuse of the model, especially in the output side, can you filter out abusive language, quote, inappropriate material, without defining what is inappropriate. One person's inappropriate is another person's appropriate. But so all of these obviously have to have some sort of a dial on them as to what you're doing. But I think we are going to see more filtering on inputs and outputs to try to mitigate some of those risks, along with whatever legal indemnifications we can get from providers.
Mm-hmm.
Right.
Yeah.
And then go ahead.
I was just saying that matches what I've seen. Most of the indemnity clauses I have seen for services are are related to copyright infringement. But I think on the technical back end, there's a lot of work being done. I think, Chat GPT is pretty well known for it. There's a constant back and forth between users and OpenAI on how, I don't want to use the term abuse, but basically use the prompts to get it to do things that OpenAI may not want you to do. So, whether that's for legal compliance or inappropriateness for whatever value judgment you want to make of that, that's I think going to be a constant back and forth if you're a service provider, and even as a user, even if you're not intending to do anything like that, you may have to change how you work with those models. If you're a service provider and offering your own product based on Chat GPT, and you structure prompts in a certain way to get a certain answer, those will change over time. Part of it due to just the probabilistic nature of how these models work, but also due to back-end work that service providers will make to increase the safety levels of their model or address compliance issues of their own. And I think that is possibly an unintended side effect of some of the laws, like the AI Act from the EU, is that I think a lot of the medium-sized businesses, unless they're targeting some very specific use case, will probably just use these larger providers because of all of the regulatory requirements. They're just going to say, it's not worth it. We don't have the technical capability to deal with it. Let's just rely on ChatGPT, Claude, whatever service provider it is. And the exact calculation of cost of compliance versus cost of using their service, I think is going to vary from business to business, of course, but something that I think you do have to analyze on the business side.
Right. And, one of the sort of ultra prudent things you can do is not retain your inputs, right? Or retaining and reusing those to retrain the model. And also, what about like retaining rights in inputs and outputs? I mean, there are rewards, but there are substantial risks, especially with the privacy and copyright infringement potential with the user inputting content that is that they don't have the rights to, and could be corrupting your own system if you're retaining that to retrain your models, or so there's a lot of risk, but it also is very organic and would allow the system to thrive on its own, potentially, hopefully in the right direction.
On the inputs and output sides, one of the tenets, we've lived by in the use of the commercial generative AI systems we're using is we make sure contractually there is no training with our input data. So no training on our input data, no storage of our input data, and it must be kept confidential. And that's both for our own company information. And of course, we're using this stuff for customers. So the customer data that might be fed into the model, those are, among other things, but those are the real base tenets we look for. And then no ownership or constraints by the model provider or model deployer on the outputs. Those are ours and ours alone.
So you own the output constraints, and you don't train on the input data. So that's sort of a business model, or the tenets of how you, at least at this time, you're operating.
Yeah, exactly. And not all commercial providers, and certainly not publicly available models like Chat GPT that you get quote for free online. They often reserve the right to improve the model based on inputs you get. we look for that, and we've seen similar things in certain commercial providers, some very large commercial providers. Um, uh, will try to get rights to improve their products based on your inputs. And because our inputs, we may not have the rights to give those commercial deployers or developers rights to our customers' data for training purposes. We have the right to use it for fulfilling the service for which we've contracted with our customers. And that may entail exposing it to a third party like a Microsoft, Azure, OpenAI services component. But we want to clip that off. So when we see that, and we have seen it trying to creep into some commercial deployments of AI models, because without data they die. I mean, there's nothing there. So they have to find the data. They know the risks of scraping the web. They see the dozen or so lawsuits, and seemingly, there was a spat of them 6, 8 months ago. But even more recently, other ones have come up for copyright content available on the internet, the being used without a license and potentially in violation of the terms of use of the website to train models. They don't want to get into that risk. So they're looking to only use, quote, licensed data. But the irony sometimes is the company is telling the customer, we only use licensed data. But what the subtext they aren't telling you is, and part of that is because you're licensing us your data, even if you might not know it.
Right.
And there's a bit of irony there in some companies who pound their chest and say, we only use licensed data, but they're not exactly transparent about who they're licensing it from, because it
Right.
might include you.
Mhm.
Right. Right.
And
And-
yeah,
Go ahead.
and on the governance side internally, not necessarily for products, but for our own employees, we're looking at things, just standard guidelines. Do not input confidential material into basically a non-locally run model. So yeah, the marketing team wants to put a marketing flyer and ask ChatGPT to grammar check it. Sure, that's fine. Yeah, that's fine. Putting source code in a development environment with Copilot enabled, higher risk, higher risk. And there's a very large degree of in between on those, but that's, as part of the governance policies that you implement as a company. I think you not only have to be concerned with the product facing use and sort of what are we going to productize, but even just how you use a model internally.
Yeah, I absolutely agree. And I think we've probably all heard about, in early days, the Samsung engineer who decided to feed ChatGPT source code to try to help them debug it. And that became used to retrain the ChatGPT model. Those sort of obvious ones don't seem to come up in the way they were in early days, but people don't read public terms of use when they're using websites or, downloading music or signing the Apple agreement at 60 plus pages now. And if buried in there, are some provisions that said we can train on it. And public Chat GPT has that provision in their terms of use. You can buy upgrades for a premium with different terms, but that can expose to you to a lot of liability. Your own confidential information, or God forbid, what you've contracted to keep confidential for your customer is now out there. That's
Right.
a very bad look and high risk.
Definitely. I mean, on the contract side, where you have like customer service agreements and and so forth. I've seen a lot of companies trying to contract for a ban on using AI when creating, providing the services, and which, you know, it seems a bit, you know, overkill, because there's certainly, you know, AI integrated in most things, you know, whether it's voice to text translation or, you know, so these all out bans are really inappropriate in agreements, because generally, because it should be more specific to specific types of, you know, maybe Gen AI, or just not an all right ban against AI tools. But in any event, let's touch a little bit on the copyright traps that are coming up. I mean, so we've talked a little bit, or mentioned a little bit about, you know, the copyright risks, and when there are outfits out there that are making a sort of a business out of setting up copyright traps with content that may be, you know, for example, like a map that may have fictitious towns on it, and providing, you know, substantial instances of the same map all over, so that it could likely be picked up and scraped, and that models can train on it. And I guess, you know, one way that the models can verify that the content, you know, may be accurate is if there are multiple instances of it. You know, the more instances of it increases the likelihood that it might be true. And so there are, you know, the enterprises out there that are, you know, selling services to try to create, you know, sort of copyright trolls that will put content out there to try to elicit it getting scraped, and to be able to show proof if the model regurgitates any of that in response to any of its outputs. And I don't know if, you know, it's kind of like creating a honeypot with fake data, you know, which is kind of an old approach to creating these honeypots in computer science, but seeing this now in the realm of trying to create these copyright traps with phantom data or fake data is interesting, and certainly, you know, something to be aware of and be careful of, because the copyright risks are real. But I don't know if you guys have had any experience or know any, you know, I mean, I suppose that there are ways to train the model to make sure to help it verify it more with the weights or so forth, but it's an interesting ploy.
Yeah, no,
Go ahead, Leslie.
I would say I haven't seen that exact scenario, but yeah, you're right. You know, the whole copyright trap that goes back to, you know, I think that was probably maps in the 19th century. You know, that's
Right.
certainly, yeah, not a new ploy, but it's you know, with Gen AI context, I think that realistically will be hard to answer in every case, because I think the nature of the output of a lot of these models is probabilistic. There is, in some cases, a non-zero chance it, you know, it says something that is identical to that, whatever that trap is supposed to be, but there's no instance of that in the training data. And it almost gets into sort of the idea expression dichotomy. Yeah, if it repeats the exact same sentence completely independently, well, it's two separate independent creations of the same work. And under existing copyright law, they each have their own copyright. Proving that, I think, is going to be a very difficult thing, because, you know, with these, particularly with large language models, you know, we don't know exactly how they work. And in terms of being able to trace a specific output back to a specific input, and how the weighting goes, you know, all of the weighting goes through the layers of training. But it's, yeah, I think it is something you could see if you're just scraping data wholesale off the internet. Um, I was thinking in terms of copyright traps, more in terms of the indemnification provided by a lot of these providers might not be as broad as it looks on first glance. I know, Steve, that's something I think you pointed out on one of our previous conversations of, the indemnification looks very broad, but there's lots of outs. If you're trying to get the model to produce content that is copyrighted by somebody else, it doesn't apply. If you're Steve, maybe you remember some of the more common exceptions.
Yeah. Yeah, exactly. And just in broad picture, and I give them a lot of credit. Microsoft did what they usually do, which is great marketing. Back in, was it last October? They came out publicly with a copyright commitment, and they made, a lot of press around that. It took them a couple of months to actually encode that into their agreements. And as Leslie pointed out, there were many backdoors, what they call technical mitigations or other things you have to do in order to stay with the indemnification. But it was very effective. I literally had executives in my company come to me and say, why are you checking so closely on our use of AI? We're indemnified. I saw the Microsoft announcement. We are clear. We're covered. And I literally had to argue with my own people that, right now that's marketing. This was when it first came out. We don't even have the terms yet. And we get the terms, I can guarantee you there are going to be some carve-outs on that, just like we see on any indemnification carve-out, patent indemnification, combination exclusions, things like that. They're going to be there. So that is one risk. The other thing, Giovanni, you were talking about sort of scraping web data and maybe there being some faulty content on purpose out there, these honeypots. There's a legal risk to that, of course. It's unclear if in the US, all the defendants are relying on fair use. Maybe in Europe, text data mining exception, the TDM exception. We'll see how that pans out. I think it's still a risk. But I think from the practical side, on the legal risk, it's fairly minimal for most companies. It's going to hit the Googles and Metas and certainly OpenAIs of the world that are building these massive general purpose LLMs. But if a company is training on data, very few companies, and I'll speak for mine more broadly, but we generally don't see us in the space of writing general purpose LLMs to compete with a ChatGPT or a Claude or a Gemini. We see ourselves building purpose-built, specific. So we'll be training on known data sets, curated data sets, hopefully licensed data sets on those things. So on the legal side, I don't see for most companies a huge legal risk with that. The practical risk, is of course out there. If the LLM you're using was trained on a bunch of bogus data, it's as old as computer science, garbage in, garbage out. If the data is, faulty, your answers are going to be faulty. Just along the same lines, if your data is biased, your conclusions are going to be biased. You have to do some scraping on that.
So you mentioned the domain-specific LLMs, and the way to get in that environment is with curated data. What steps of curation do you look for that data set to be able then to say we can feel that we've mitigated risk because we understood how that training data was curated?
So our perspective, I think companies differ, but clearly, step zero is the license. can we use it for the use case? Are we properly licensed to use it correctly? And then it comes to a bit of the pedigree, is somewhat like diligencing open source software. You make sure your license compliance is clear, and then you potentially look at pedigree of it. And here with the data, where did it come from? Was it trained by Mayo Clinic or, compiled by Fuzzy Mom 14 on the internet? Um, there's a difference in health data when it comes to that. So I think those are the two fundamentals you have to look at is a license compliance and a pedigree on the data.
And I agree. And I think, very similar to the, you know, with open source software, I actually do like that analogy. With, we not only have the licensing concerns, but like pedigree concerns of, from a cybersecurity perspective, are there known vulnerabilities? What is the project's history of patching vulnerabilities when they come up? Is it from something, from the Linux Foundation or Apache Foundation, something that's well known, or is it somebody's random GitHub project? Yeah, those are all, they're subjective questions, but they're still important questions to answer. And I think you do have a lot of that with a lot of those same questions with data curation. I'm for my company, we've, you know, yeah, like you said, Steve, it starts with the license, but it doesn't end there. Um, but with very niche use cases, you start to see, you start to get into data sets that there just isn't a lot of public data to begin with. We've got products that are used for computational fluid dynamics. So, aerodynamic simulations. Companies generally do not post those results of their products or products in development online. Sometimes they can't because they're, if they're export controlled data, that's, there's a whole nother set of laws you have to worry about. So I think in a lot of these more domain specific models, the questions get a lot deeper. I pick the CFD one because if it's the aerodynamic simulation of a jet fighter wing, yes, that's probably export control data. So you have a whole lot of other concerns of, well, not only are we doing training, where are we doing the training? And if you want to productize that, who can you make it available to? Those are some very fun questions, but that I'm not sure anyone has a full answer to, at least yet. But
at least in a domain specific environment, like you said, which lane to stay in, the ITAR, the other regulations that are going to come into play because you're focused in that particular domain specific area and the data that you're wanting to use and looking for. So in some ways, yes, it opens up many more different agencies' regulations to have to comply with, but it should not be of any surprise because your particular boundaries are in that environment.
Yeah. Well, and yes, and it allows you to do that due diligence on your data to a much greater level than just say, oh, we scraped the 5 million most popular websites on the internet and scraped whatever our robots could scrape, to we have these 10 data sets from these 10 companies that each agreed to let us have access to this data. They did the ITAR clearance because they wouldn't give, we're a French company, we have a US clients, that's a common back and forth. We know by the fact that we have the data that assessment's been done. Independent, and then we have, of course, still have our own independent analysis to do. But I think for the more domain specific models, you can, because the data sets are a lot smaller, you can go to that level of detail that you can't realistically do if you're doing something like an LLM, that's trained on, billions of lines of text. Well, more than that.
And then at the reaction half of down the line, if there becomes some bug or known vulnerability, then at least you've kept good record of the source of the data and what I's were dotted and T's were crossed. And then if the vulnerability does have impact to your specific model based off of the information coming out, then I think it helps one manage their risks on both sides, the training data side as well as the vulnerability side down the road when those bugs come to be known.
Right. So making sure you're using trusted sources for your for training is important. But there's also, for at least for the large language models, there's an advantage to not knowing, too much or saving too much of a record, because then how could anything be sort of traced if there's a potential copyright infringement issue? Not that I would recommend that route, but there is not, if you don't know, if there's no record or no track record and you don't keep copies of your of each iteration of your training data or prior versions of your models, then if it's very dynamic, then that may behoove you.
Yeah, I think if you are training or scraping to get your training data, and I think we're seeing this coming out. We were talking a little bit earlier, Leslie mentioned it, requirements of the EU AI Act and respect the opt-out that the content owners have the right to. And we'll have to see what that turns out to be. Technical opt-out with robots.txt, is a classic.
Right.
One, I would expect, but I don't know, to your point, Giovanna, that all of these large language model builders that have scraped the web have complied with, those technical opt-outs. Don't scrape my website, as opposed to, ignoring those. But right now it is completely impractical, I think, for them to even keep track of what they're doing in detail. They may be able to identify each website that was visited, based on their technology. But in general, I think they just use more of a free reign across the internet, as opposed to, as Leslie was saying, here's the 5 million most popular websites, let's scrape those. I think it's a much more far-ranging way they generally would do it.
And what about using Gen AI to train and scrape and create new open source software? What are the risks and the benefits in that domain?
Yeah, and I think the still unanswered question, and I know we've discussed this privately and publicly for you, to what extent is the output of a generative model a derivative of its input? That's a still unanswered. Could fall down to the famous lawyer answer, it depends. But
Right.
I don't think that's something we're going to have a quick resolution on. That I think that's something that's ultimately going to be litigated. There will be, there's probably going to be a Supreme Court decision a decade from now. Not going to try and read the tea leaves of the current Supreme Court or what it could be then.
Right.
But depending on how risk averse you are, you might be willing to say that's something we're willing to accept. The advantages of our development time, reducing our development time, are worth it. And if it crosses that point, if it gets to that point where we say, okay, this, we use a model trained on open source code, used it to write our proprietary code, it's now subject to that open source license. What do we do now? For some companies, that would be an existential risk, depending on For others, they may not care. If you're already a company that's writing your code and producing it open source, other than the attribution requirements, you may not care. Um, so I think that's basically comes down to how much do you care about your own product source code. It's something that we've looked at, and that's for my company that's not an acceptable risk. But I could see other companies going the other way, just saying, well, the advantages are worth it, and if it changes, we'll reassess when it changes.
Yeah, I agree. And I think it is going to be a fascinating question for the courts in years to come to make that distinction as to what is a derivative work of the inputs when related to the outputs of the model. The classic analysis, I suspect, is going to apply, but the devil's going to be in the details. Did you have access to the work? And is it substantially similar? And you focus that analysis on the outputs. The substantially similar, I think, will be the same analysis, framework we've used for years. Did the end user of an open source of an AI model, AI model, have access to the input? Well, as Leslie pointed out, you had access to the model. It's made up of weights in the neural network. It's made up of matrices of data, and matrix math gets applied to that data, and it spits stuff out. Though I think everybody would tell you that a verbatim copy of the work is not within the model. It's not that you can find text to Gone with the Wind in the model. But can you produce text that is similar to the Gone with the Wind story? Very likely, if it was trained on that. Is that access? Does the trainer have the right, as a human does, back to the idea expression dichotomy, does the machine have the right to learn or train on the concepts of a work in the way a human does? Or is the act of training it by copying the data set into a compute space that can then curate the data and feed it into a model to be learned, and arguably the output doesn't contain the work anymore, but it contains the concept or the essence of the work, and it can reproduce something related to that, just like a human can read Gone with the Wind and write their own novel. But the question becomes now, is it substantially similar? The human there's no argument. You had access, you read it. Does the end user of the AI model have access? And does that indirectness protect you?
And I think,
Go ahead.
and I think it could change very much on what the model is trying to do. If it's a large language model versus, say, a model designed to output music or video, because those exist now. And we can, fair use is a very fact specific domain. We saw fair use, in the Google Oracle case from a few years ago. Google copied millions of lines of code. That was fair use. But in the music world, you've got cases where artists have basically said, yeah, I used a single chord progression or a single bass line, would have 4 to 5 notes. And that was found to be copying and not fair use. So there's depending on, you can't just say copyright law. I think you have to look at very specifically what the model does and what type of output does it have. I think you could I could see a scenario where we have different passive litigation for different types of works that end up very differently just based on historic fair use cases that can turn out very differently depending on the type of work.
And I can also see, so derivative works to be copyrightable still would need to be a human author. So there's the argument, well, the Gen AI model is not human, and that's what produced this next series of source code that is the subject being argued. So I can see a creative copyright attorney saying that that's not copyrightable derivative work because there is no human author. So I think you're right. It remains to be seen down the road, all the different legal interpretations based off of what we currently call copyright law and case law, because as Steve outlined, the two-pronged test is access and substantially similar. But I do think the door is open to argue there's no human author.
And I like what you're saying, Leslie, about it, sort of depending on if you're going from like text to music or text to video, like that is an instance where it could be really transformative, or, just because of the input being different from the output, or that would seem to give some sort of, help the fair use factors, as well as, but I guess again, it depends on, what's in the model, and what was it trained on, and how close it comes to any potential copyrighted work. But it is going to be fascinating to see how this plays out, and I'm really excited to find out, and hopefully hopefully the Supreme Court gets it right when it does make it there, because we could be in a situation where we have very bad law that will impede technical progress. So we have some questions from the audience, and we have a question: what about organizations, people doing illegal things or worse? Would they not care about the restrictions on open source or legal constraints about how AI could be built or used? I'm thinking of fake AI generated audio or video generated for porn, or to steal identities, AI systems designed to attack nation states. So it's, reminds me of what we've talked about before about, one of the protections that I think that Congress, is looking at is the Copyright Office, Digital Replicas Act. We've talked a little bit, Leslie, you were chatting about that, which is interesting, which may sort of provide a new type of protection, IP protection, in this space, the sort of catch-all for this stealing identities, maybe an extension to the right of publicity.
Yeah. Well, and yeah, and I think that's a good point. If somebody's already doing something illegal, they probably really don't care about copyright infringement that much. If they're, so I think you'll almost like now you will, in the cybersecurity world, you have everything from individuals in foreign countries that know that they're basically beyond the reach of, US and Western law enforcement that try to scam people and steal credit cards, all the way up to advanced persistent threats, that are basically nation state actors. They will use these models. I don't think there's really any way to prevent that. Less as a legal opinion, just more of a general one. Once the technology is out there, the genie's out of the bottle, it's not going to be put back in. What I think you will have is you will have laws that try to cover use within your own jurisdiction. I mean, that's, US is looking at that now, like you mentioned, with the sort of trying to create a new IP-like right for likeness at the federal level that already exists at the state level. But it also means, you won't be able to use US service providers. If you run a seed box and you try to torrent a bunch of copyrighted content on an AWS server, it will be up for a while, and then Amazon will see what you're doing and shut that account down. If you run that on your local, on a local device that you own, sooner or later your internet service provider will get a DMCA takedown from the content owner and they'll forward it on to you. And if you do that too many times, your ISP shuts you off.
But it's already out there. The harm is done, right?
Yeah, it's already out there. Yeah, it's already out there. The harm is done though. But if you have if you tie that to something that's within basically U.S. jurisdiction, then obviously U.S. law applies, and you won't be able to avail yourself of those types of service. So yeah, if you're running a deep fake model for the purpose of influencing a lot of election or extorting somebody, and you're doing it on a U.S. service provider, that from a law enforcement perspective makes it easier to trace to you, but B also means that you're always on the clock on those types of services before somebody basically detects that and you get shut down. So I think you're going to see services, for lack of a better word, that are outside of the reach of U.S. law enforcement and jurisdiction using these tools. That's unfortunate, but the future we live in, I think.
Yeah, not too much to add, but bad actors have existed since the beginning of time. They'll continue to use whatever tools of the day are available. The AI systems are more powerful than some of the software that was abused before. But as was pointed out, if you're doing bad acts, copyright infringement is probably the least worry that you have. The only other practical thing I'll add is, again, with the data input filtering, the more you can prevent potentially damaging data like personal information, health information, sensitive private information, financial information going into the model in the first place, the less likely that sort of exploitation will happen. Deep fakes and other things that people just abuse the data that they have, images, voice, video, to conjure up something that is not true. That's right now, I think, going to be one of those defensive based things that you play whack-a-mole. You make it illegal, and as Leslie was pointing out, in the jurisdictions where you can trace, have more enforceability, some of those actions, you might be better off. But I do think it is a worry, certainly of the regulations, the regulatory bodies, the Biden's Executive Act and other things, to have the agencies in the U.S. anyways put in place protections against abuse related to their particular, subject matter or agency. But it is an uphill battle.
Right, and I think there's a lot of IP opportunities, and I've seen a lot of activity in this space in terms of, filtering out or anonymizing, creating, making sure that any content is filtered out for personal data, just to comply with all of these legal regulations. But it's a major technical problem. It's hard to do, but it's certainly an important one, and it's a big an opportunity to create a technical feature that could help solve that problem. And just from the IP perspective, I've seen a lot of activity in that space, in the sort of privacy compliance space.
Yeah, and I can see that being honestly a good opportunity for businesses, just as there are brand monitoring firms of, did somebody try to register a domain name using my company name? Is my company name being used used on a website without our knowledge, or a similar logo? Yeah, that's an active business. And even data brokers, there are services you can sign up for that will, on your behalf, try to actively get your information removed from data brokers. Sort of niche field, but something that I know exists. I could see something similar popping up of, monitoring the open web for, are people making deep fakes of me? You know,
Right.
somebody using my likeness to endorse some product in a foreign country I've never been to. Yeah, I think, yeah, probably not something most people will avail themselves of, but if you are particularly famous, that's, yeah, that's something I think could be a nice product for, uh, say the Taylor Swifts of the world. She
Right.
probably doesn't want to endorse products in, 200 countries.
Right.
without compensation.
Right.
Right. Um, so in your opinion, this is another question. In your opinion, do you think in its current state, laws, regulations are still trying to figure out how to move forward and probably will have more restrictions or limitations once the landscape is more stabilized? So we see that we've seen there's attempts, obviously with the EU AI Act, and then now we have the Copyright Office throwing their hat into the ring with the digital replicas proposal. Um, I think that I think that I think that the current regulations and laws are sufficient. I don't know that that it makes sense to create new law just because it creates so many hurdles from an innovation technical perspective to, I think it impedes innovation. And it's not always done thoughtfully in a way to ensure that, innovation will not be stifled by these regulations.
Yeah. It would, when it comes to the IP risk, I absolutely agree. I think our current IP regulatory regime is robust enough to absorb what I've seen so far in AI and generative AI. Will there need to be some case law as to whether or not fair use, for example, covers training data models? I think so, but I don't see for the US anyways, an AI specific IP regulatory change. I do think case law has to be developed. I think the regulatory agencies, principally the Copyright Office, is going to have to struggle with coming up with a regime to on the spectrum of uncopyrightable without human creativity, you know, just a simple prompt writing, a book and that book being copyrightable um, is, the case right now is it isn't. You need human creativity. Um, is it on the spectrum? Is it a tool you used, the AI, system? Like, famously the camera used by the photographer in the 1880s, who was challenged to say photographs aren't copyrightable. Well, it was just a tool. The paintbrush before that was a tool. Just because you made a painting with a paintbrush doesn't mean it's not human creativity. But where on the spectrum uh, is, because as we generally know with works of authorship and creativities, we stand on the shoulders of previously written works. Code that comes out of these systems has to be tweaked. So yes, was it code but modified by a human? Does that make it copyrightable? Is it just because you tweaked one variable, or do you have to tweak 30 lines of a 100-line program? Nobody knows. I think that we will still see the current state of, quote, the law change, but I don't think we'll see new, wholly sui generis AI IP regulation.
Yeah, no, I agree. I think there will be basically a burst of new laws at, state, federal level, these proposals. I mean, I don't know if any of them will be successful, but I don't expect a whole new regime. I
To the
think,
extent they are, I think they'll be around the use case protections. Don't use AI to discriminate on financial decision. Don't use AI for this or that. Don't use privacy data. The kind of things we've seen before, but not, in my mind, core IP.
well, and I think people will sort of take a step back and realize, like, well, if you're using an AI model to extort somebody, well, extortion's already illegal. I think people will take a step back and say, okay, well, what laws already apply? And there will be practical difficulties in trying to enforce some, and particularly deep fakes. I can see that, depending on what they're used for, but creating a likeness of somebody in itself is not illegal. So, not only on the IP side, but I think in criminal law, election law, and take your pick, people will look back to existing legal frameworks and say, how can we apply it? And does AI really change the calculus on what you're actually trying to do?
Right. Well, I want to be mindful of time, and I was just wanted to, if we could each go through and give a little takeaway. And I'll kick it off. I just, in general, I think AI is a powerful, promising tool and technology that many sectors, can take advantage of, and it is very exciting, and it has the potential to augment like the healthcare, gaming industry, so many different types of industry, analytics, content development, artists. So it's very exciting, but certainly we need to, make sure that we comply with the legal requirements and safeguard, the irregularity and reliability of the models that you're using, and implement robust security measures, and make sure you get trusted sources that you're getting your models here through, and that whatever tools you're using, just and look for the indemnity as well, as our speakers have emphasized, and to read the language carefully to see what it applies to if you're going to use a closed model. And but it's definitely something to look into and take advantage of, and we're here happy to help and navigate the legal landscape when it comes to compliance with all of the different regulations, as well as to help you protect your IP in your AI models and your implementations. Thank you. Anyone else have anything to say to our guests before we go?
I'll say one takeaway, I think, to sum up on the purpose-specific LLMs, as we have discussed over the last hour plus, the benefits seem to outweigh the risks, both on the steps for curation of data and understanding the source of that data, and being on the one end, the other end being the output and output side, combined with filters and being able to manage and control that. So I think, as Steve was saying, the due diligence is outlined for one if you're guided by your domain specific or purpose for that LLM.
Great. Well, thank you guys. Thank you all for listening to our panel. And I want to remind you, we are going to have a follow-up discussion on October 17th to talk about what's happened between now and then. So long, thank you. Bye-bye.
Thanks all.